Good afternoon, and thank you for joining us today for our webinar regarding the new proposed Title IX regulations. My name is Melissa Riley. I am an attorney of counsel in the Charlottesville, Virginia office of McGuire Woods. And I'm just going to give you a brief introduction to myself and the other two presenters, and then we'll launch into the substantive stuff. So I, again, am in the Charlottesville, Virginia office of McGuire Woods, and my practice is primarily in the areas of education and employment law, and I'm the deputy lead of McGuire Woods' education industry team. Our next presenter after I'm finished will be Craig Wood. Craig is also a partner in the Charlottesville office of McGuire Woods, and he also focuses his practice on education and employment law, and he's a former lead of our education industry team. Both Craig and I work extensively with educational institutions throughout the country on both K through 12 and higher education issues. We have broad experience with Title IX issues, which includes everything from crafting those policies and interpreting them to assisting with investigations, hearings, and appeals, and handling Title IX litigation on behalf of colleges and universities. Our third presenter will be Mark Hubbard. Mark is a Senior Vice President for Advocacy with McGuire Woods Consulting. He focuses on crisis and strategic communications, media relations, and issue advocacy. And our attorneys frequently partner with Mark on education-related issues, and he's been very helpful to us on dealing with public relations issues related to Title IX matters in particular. So with that, we'll jump into what we're going to cover today. What we have decided to split this into is 3 different segments. First of all, I'm going to be talking about changes to really the overall Title IX program requirements and handling of complaints up to the filing of a formal grievance, which would initiate the formal Title IX grievance procedures. Then Craig is going to take over and talk about changes regarding the formal grievance procedures and beyond. And then Mark will finish up discussing public relations issues related to implementation of new policies and procedures as a result of these proposed regulations. We will not be going over every individual change that these proposed regulations include at this point. You probably have read plenty of articles that sort of summarize those changes and may have even read through the actual proposed regulations yourselves. We thought our time today would be better spent really talking to you more on the changes that we think will have the biggest effect on schools and to help you think about where to go from here, and some strategies to be ready for these changes and what you need to be taking into consideration as you look at your policies going forward. We will be focusing on legal questions. Craig and I are both here today as attorneys, and as you know, attorneys' jobs are to address risk. And so we're going to be talking about how to limit risk under these new proposed regulations. We want to acknowledge up front that what you and your school may want to do from a policy standpoint may differ from what we advise may carry the lowest risk. So we're not here to talk to you about what your policy should be necessarily, although we will be addressing some of those issues, but we are more just going to be talking about this from a legal standpoint today. Also, in our discussions, we're not passing judgment on what we think of these regulations. We're just kind of telling you what the regulations or the proposed regulations are and what we think you're going to need to do to comply with those. Finally, I wanted to let you know, if you have questions as we go along, there is a format on your webinar or platform where you can submit questions. Given the short amount of time we have to cover a lot of ground today, I don't know that we're going to be able to get to all of your questions. If we have some time at the end, we will take some questions as we can. And if we cannot get to them, we will respond to them after the webinar. So we will get back to you on your questions. Just before we dive into the substantive pieces of this, keep in mind why things are different this time around. During the Obama administration, there were a lot of changes in Title IX that were implemented through guidance such as the Dear Colleague letters. And those were, when the Trump administration came in, they simply rescinded that guidance because it was guidance. What the Trump administration is doing this time around is the Department of Education has issued these proposed rules. And these are not going to so let's say in the next election we have a Democrat come in. That doesn't mean that Department of Education under that administration will simply be able to rescind these rules once they are finalized. They will have to be changed through formal rulemaking in the same process that the Trump Department of Education is going through right now. So we do take these changes quite seriously because they can't simply be rescinded with a stroke of the pen. And we want you to remember that now is the time to have input if you want it. What happens is once these proposed regulations are published in the Federal Register, there will be a 60-day notice and comment period. And you can submit any issues you have or things that you like about these proposed regulations, and then the Department of Education will issue the formal rules based on that. So if you want to be heard, now is the time to have your voice heard. One final note, and then I'm going to jump straight into, oops, sorry, I have two final notes. First of all, remember these regulations are not final yet. They may change between now and when the final regulations are issued. And we have some ideas of what may change by looking at what are called the directed questions that are included in the proposed rules. And those directed questions sort of give us some hints as to things that may still be up for further debate. One in particular is when Craig gets to his portion of the presentation, he will talk about the new standard, the evidentiary standard, and whether it should be clear and convincing evidence or preponderance of the evidence. One of the directed questions the Department of Education has put in its proposed rules is whether it would be preferred for the department to simply say you should use this standard instead of allowing schools to choose what standard they use. So that is something that we may see change. The reason this is important is just what we're suggesting to you today is what we think you need to be looking at should these regulations become permanent as they are written today, but it's important to remember that may change between now and when they are finalized. And what we would recommend that you do is to start planning, but don't yet implement your changes, because then you might just find yourself having to make a whole nother round of changes. So our final note before I get started is just so we're all on the same page. We may, during the course of this webinar, refer to the complainant as she or her and the respondent as he or him, simply because that's generally the most frequent pattern we seem to encounter in Title IX cases. But we do want to acknowledge up front that men and women may both be complainants and respondents, and don't intend to imply otherwise by using simplified pronouns. As we would say if we were drafting a contract, any use of any particular pronoun should apply equally to all males and females. Finally, a lot of the rules refer to the recipient, and just so that everyone understands the terminology we're going to be using, a recipient is a school or an educational institution that is receiving federal funding such that Title IX considerations will apply to it. So when we use the term recipient, we'll be referring to the school. Okay, Launching into the overall, some of these overall arching changes, the biggest change, which really is going to be a positive for colleges and universities, is that the standard for liability is going to be changed under these proposed regulations. What has been proposed is a standard of deliberate indifference, which means that a school would be liable for violation of Title IX only when it is deliberately indifferent to known sexual harassment. And deliberately indifferent is being defined based on some case law that has been developed as clearly unreasonable in light of the known circumstances. This is going to be helpful to schools. Before, a school had to show that it acted reasonably, and that sort of allowed the Department of Education to impose its own thoughts as to what should be how a school should have reacted. Now, instead of the department imposing its own thoughts on what is reasonable, it's going to have to make a determination that what a school did was clearly unreasonable. So it's really going to give more deference to the schools. And the regulations, the comments to the proposed regulations, do state that the mere fact that a different result may have been reached had the DOE made the assessment does not equal deliberate indifference, and the department is not going to second guess decisions by schools. And this is really good because you as administrators and attorneys for schools understand the unique culture of your school, and what may be appropriate at one school may not be appropriate at another. So this standard is going to be very helpful for schools in the long run to be avoiding liability for its Title IX decisions. So some actions that we're recommending that are going to help promote lack of liability, if you want to put it that way, for institutions is, and this is nothing new, we've been saying this all along, you want to have well-documented policies. We're going to be talking about reporting routes, and it's really important to have those defined clearly in your Title IX policy. And it also is going to mean having clear policies for other types of conduct that may not fall under Title IX based on these new proposed regulations, such as your student misconduct procedures. Another couple of keys, things that we take overall from these proposed regulations is that they want to see schools being responsive to complaints. That does not necessarily always mean that complaints are going to be investigated as a Title IX matter, but they want to see schools responding to complaints. And they also want to ensure that there is not bias on the part of the schools. So they don't want schools going into this with an agenda. They want to ensure equal protections for all parties. So those are just some overarching ideas that we want you to keep in mind as you think about these new regulations. So let's talk about what conduct is covered under these new proposed regulations. The regulations talk about conduct that occurs within a recipient's educational program or activity. One of the frequent complaints that the department received regarding prior guidance was that it really required schools to investigate things that occurred off campus in locations that had nothing to do with the school. If there were two students who were in a different state over the winter break, schools often felt, and something occurred there, schools often felt that they needed to investigate that. So these rules are trying to more narrowly prescribe what conduct a school has responsibility for. Now, it talks about educational program or activity, but the rules make clear that it's not necessarily going to be limited to the geographic location of the incident. So it's not just going to mean things that occur on your campus. Some of the factors that the comments talk about, and they draw these from case law, are: does the recipient, meaning the school, own the premises? Does it exercise oversight, supervision, or discipline over the over the place where the conduct occurred, and for that particular factor, I would point you to schools that may not own fraternity houses, but that have fraternities that are governed by policies of the school. So that goes to this: does the school exercise discipline over those organizations? And another factor is, does the recipient fund, sponsor, promote, or endorse the event or circumstance? So this is going to limit really what kinds of activities and conduct the school is responsible for responding to. Another important thing to know here is that the proposed regulations talk about conduct that is alleged against a person in the United States. This is really interesting because it can have a great effect on, for example, study abroad programs. So if you have two students who are studying outside of the country and one is sexually assaulted by another, that does not necessarily fall within Title IX under these rules. So one thing to take from this, and that the rules make clear, is that schools can still refer incidents that do not occur in its educational program or activity to student conduct proceedings, or they can offer supportive measures. I think what you see the department trying to separate out here is what is going to constitute a Title IX issue that requires you to go through all these things. They're not saying you should not that you shouldn't address conduct that falls outside of this conduct that they're saying is covered, but it does not have to be addressed through the Title IX procedures that Craig will be talking about in a little bit. So you're going to need to make a decision about how you want to handle things. Maybe if someone is in a study abroad program, you still want to be addressing those issues, and I can imagine that from a policy standpoint, schools would want to do that. But you're going to need to look at your policies and define what policies will be handled through Title IX versus through student conduct committees and things like that. So just some things to think about. Conduct that occurs at an off-campus party would not necessarily be included under this definition. However, what if both of the parties that were involved resided in the same dorm and the conduct sort of overflowed and it carries over to the dorm? When you're determining if you have actual knowledge of a Title IX issue, which we'll talk about on our next slide, you may have to take that off-campus conduct into consideration to determine if, when you lump together all the circumstances, it constitutes sexual harassment under these Title IX regulations. So there may be times when you would still need to consider that conduct, and there may be times when you want to include that conduct in something that you determine independently arises to the level of a reportable incident that you are required to report under these new regulations. And again, you may want to voluntarily require or voluntarily agree to cover certain things like fraternity houses. Again, this is a policy decision that you're going to need to have discussions about, and we can provide guidance as to how to limit your liability, but also meet policy goals for that your individual school wants to accomplish. Okay, so now let's talk about actual knowledge and when a school has not actual knowledge for purposes of Title IX that requires further action. The proposed regulation says that actual knowledge is notice to a Title IX coordinator or any official of the recipient who has authority to institute corrective measures on behalf of the recipient. Some of the issues here are: who are those people how are you going to define the people who have authority to institute corrective measures? Do you want your Title IX policy to say the following people are officials with authority to institute corrective measures and list certain people? There's some that are going to be obvious. The Title IX coordinator, deans, but there may be others who do have an ability to institute corrective measures that may not be quite so obvious, and those people need to know who they are. That's number one thing when you're talking about training and things like that, but also your students need to know who they are. And again, this goes back to having a policy that clearly defines this so that students understand how to assert their Title IX rights. One thing to keep in mind is that the new definition of prohibited conduct, and we're not going to spend a lot of time on this given our time limitations, but the new regulations propose a definition of sexual harassment that sort of mirrors what we use in Title VII employment cases that requires severe or pervasive harassment. And so, again, there's going to need to be some training with the people who have this corrective authority to understand what constitutes a violation or what constitutes sexual harassment under Title IX. And one of the things that we've been talking about is whether a stray comment that standing by itself might not constitute a actual sexual harassment under Title IX, but when combined with other stray comments may add up to a Title IX issue. These are some things that you need to talk about with your administrators who are officials with the authority to institute corrective action. You need to be thinking about all these things. Importantly, you need to think about whether you want to require, so under these new proposed regulations, professors and people like dorm counselors may not qualify as people who have the ability to institute corrective measures. But do you still want to require reporting by those people? If you do, what you need to do is take it outside of your Title IX policy. So instead of having it be part of your Title IX policy, it needs to be part of your procedures and policies that faculty are required to adhere to. So it essentially becomes a disciplinary issue rather than a Title IX issue. So if a professor knew that a student had been sexually assaulted and didn't bring it forward, you could discipline that professor under your employment policies, but that professor would not have necessarily exposed the school to liability under Title IX. So you want to think about how you want to, or do you want to continue to require reporting by people who are no longer going to be mandatory reporters. The regulations also make clear that there's only liability for a recipient's own misconduct. There's not going to be liability for conduct of employees or third parties. Again, and when you're talking about the recipient's own misconduct, it's the school's misconduct, okay? So it's not going to impute liability, again, for employees that have knowledge. The rules are attempting to simplify and make it clear to schools what kind of conduct is going to fall under Title IX so that there's not this sort of amorphous gray area of what has to be reported. The proposed rules also make clear that this is a very fact-specific inquiry. It is not appropriate to just say that every dean is an official with the authority to institute corrective action. The rules acknowledge that these roles vary at different schools, and so there can't be some across-the-board rule in that regard. Okay, when you get a complaint, the proposed regulations really want to divide out a complaint from what we will call a formal complaint later on. So there is a response period before a formal investigation starts, and during that period, these rules will allow you to engage in informal resolution procedures, which previously you were not permitted to do, and also provide supportive measures to the students. This is the time when you're basically triaging complaints and trying to decide, is this a formal Title IX complaint? Is this something that should be handled under student conduct? Again, you can still, if it's not a Title IX issue, you can still provide supportive and interim measures. There's nothing preventing you from doing that. It's just saying we don't have to handle this as a formal Title IX complaint. So the big points here is not all complaints are going to result in formal investigation. The part about informal resolution procedures, you need to determine what the complainant wants to do. Part of the goal of these rules is to put the control back in the arms of the complainant. If they don't want to move forward, they don't have to. And again, you should not be pushing an agenda here. It should be up to the complainant as to what they want to do. And you should be offering non-punitive supportive measures to both the complainant and the respondent. Now, what are these supportive measures? The goals, according to the proposed rules, and there's really no big changes here except for they really are emphasizing that they should be non-punitive. But the goals are to restore or preserve the complainant's access to his or her education without unreasonably burdening the other party, protecting the safety of all parties and the educational environment, and deterring sexual harassment. So the big thing here is you shouldn't just automatically say because two parties are in the same class together that the respondent gets removed from a class. You have to do an individualized assessment each time and see if there's a way to preserve the complainant's access to education without taking a punitive action against the other. Now, there are going to be situations where somebody has to be removed from the class. And in that situation, I would still say that the equities are going to say that you would remove the respondent rather than the complainant. But this is really going to require more of an individualized assessment each time, and these cannot be punitive. The other keys, takeaways here are these services have to be free of charge. So if you're offering counseling, it should be free. It should be offered to both parties, and you should maintain the confidentiality of both parties to the extent possible. I'm going to quickly talk about informal resolution because, again, this is back on the table as a possible response. And this is something that we saw a lot of schools really liked before the Dear Colleague letters, took away the opportunity to do that. So I think this is something that a lot of people are going to be interested in doing. There are lots of possibilities here as to what informal resolution can look like. It can be mediation. The proposed comments talk about possibility of arbitration. I don't think arbitration is a really great solution here because it's very similar to what you would be doing in a formal hearing procedure. So I think it's just going to add more administrative red tape. So I wouldn't recommend you go with arbitration, but it is mentioned as a possibility. There are also interim measures you can take, such as no contact orders, things like that, and obviously providing training and education. So the idea here is that you can offer a number of solutions, which, maybe you have a student who just says, I don't really want to complain about this person formally, but I'd like to see him take some training so he understands what the true meaning of consent is. If that respondent is willing to take a training class, that can be the end of it. You document it, and you've done your job, and you're not being indifferent, deliberately indifferent to the needs of the client, the needs of your complaining student. So there's just a whole panoply of options you can explore here. With mediation in particular, you need to think about who will act as your mediator. You want to provide them with training because obviously these are people who are dealing with sensitive issues. Do you want to bring in an outside mediator? Do you want people to be allowed to have advisors in mediation? Generally, mediation just, is the parties, but maybe one party has an attorney. Do you want to allow that person to sit in on the mediations, or do you maybe just want to allow the students to consult with advisors before they make any decisions, but maybe they don't participate? And then there's the issue of, do you want to make what happens in the mediation binding? Again, that kind of goes back to the arbitration aspect of it, generally mediation, what's decided in the mediation will be binding at the end, but mediation is more of coming to a solution that works for all the parties. A couple quick things to remember with regard to informal resolution, and these are part of the proposed rules. Prior to engaging in informal resolution, you need to obtain voluntary written consent from the students. You also have to provide both students with a summary of the allegations, the requirements of the informal resolution process, and the consequences of participating, such as are there going to be disciplinary measures that can be imposed. You also have to remember that the informal resolution is a completely voluntary process, and at any time a student can revert to the formal complaint process instead. The final topic that I'm going to cover before I turn it over to Craig is what is a formal complaint. The proposed regulations prescribe that a formal complaint is a document signed by the student or Title IX coordinator alleging sexual harassment against a respondent about conduct within the school's educational program or activity, and it requests initiation of the grievance procedures. So this is, I've kind of underlined the terms in there for you that you need to make sure you're meeting in order for it to be a formal complaint. The second type of a formal complaint is if you have actual knowledge of reports by multiple complainants of conduct by the same respondent that could constitute sexual harassment, you as the Title IX coordinator or you as the institution have to file a formal complaint on behalf of all of those complainants, but you would actually be the complainant in that case. If a complainant does not wish to file a formal complaint, then you just need to inform the student of his or her right to pursue a formal complaint and his or her right to do so in the future if they want. Again, it just goes back to having open communications and making sure that everything is well documented. You can also offer supportive measures to students who don't wish to go through with formal complaints. If you do all these things, then you don't have an obligation to take the complaint further unless it falls into this second situation on the slide where you have knowledge of reports by multiple complainants. This second situation we think can be a little sticky. I'm already going well over my time, so I'm going to turn it over to Craig now, but I hope that we have some time at the end to discuss it a little bit further in the question and answer period, because I think there are some gray areas in there where you may need some additional guidance. So with that, I'm going to turn it over to Craig to talk about what happens once a complaint is filed.
Thank you, Melissa. The regulations have a significant section on hearing procedures, and understanding these hearing procedures is very important because following them creates a safe harbor. So that there is a focus in the comments that go with the regulations on what has been perceived by many people who have had input into the regulations, and you read about this in the media all the time, that presupposes responsibility and that these processes used before have presupposed responsibility and have favored the complainants and haven't really been equitable. There hasn't been a level playing field is sort of an underlying assumption here. And yet the comments and the regulations themselves still emphasize the supportive measures that should be in place for a complainant who is going through the process. And so as you read the comments and the regulations, you get a sense that there's a lot of attention being paid to what is fair for both sides and enables the school, the recipient, to meet its Title IX obligations. If you have a conforming grievance policy, and if you follow that policy, you're going to be in the safe harbor of not being deliberately indifferent. So part of your risk management, as Melissa mentioned earlier, risk management focus should be on making sure that your policies and procedures conform with these procedures as set forth in the regulations, and that people are trained in how to properly implement them. So it's not just that we have a procedure, but that we actually follow the procedure so that we can enjoy the safe harbor of reduced liability. Now, this is a departure from some of the current case law. We see cases where judges have been substituting their own judgment for that of the institutional decision maker. We've seen cases where courts have decided against colleges where the court found what they refer to as plain error. And again, that goes back to what Melissa commented on earlier, that the Department of Education would do is put its own judgment in place of the judgment of the schools. And these regulations would say that's not an appropriate way to analyze these cases. So the regulations really focus on the process. Is the process discriminatory and not on the case-specific outcomes of that process? So good procedures and compliant procedures are going to be essential to managing your litigation risk. And if you follow them, essentially you've eliminated, for the most part, liability risk. A big departure from the Obama era guidance is that the single investigator model is being rejected in these regulations. The regulations are clear that the person who, or panel, they refer to it as the decision maker. The decision maker can be a single individual or a group, but the decision maker at a hearing cannot be the same person who served as the Title IX coordinator for the institution or as the investigator. Now, the single investigator model, where a person, often the Title IX coordinator, does the investigation and then, based on that investigation, makes a determination of responsibility as to the respondent and then what remedies would be appropriate. That model has worked well for a lot of institutions, especially smaller institutions, because it's efficient, it doesn't tie a lot of people up, and quite frankly, a person who understands the sexual misconduct area, which the Title IX coordinator does, is often able to make a determination on credibility and the other issues that you would make in a hearing. But nevertheless, the access to that single investigator model is no longer going to be current. It is okay for the Title IX coordinator to serve as the investigator. So two of the three roles can still reside in the Title IX coordinator, but it's not going to be that neither of those people can serve as the decision maker. Now, there is a lot of attention paid in the proposed regulations to making certain that the investigators and the decision makers are free from bias or from conflicts of interest, both in the investigation process itself and then when you get to the formal hearing process. So one of the things you're going to have to consider here is, where are your decision makers coming from? And how are you going to ensure that they are free from bias or don't have a conflict of interest? For instance, we've seen this in actual practice in some of the cases that we've handled. If you use faculty to serve on a grievance panel to be the decision maker, are you going to do your own research and consider their research and publications? Do they have a public position on sex discrimination processes or procedures or issues? I mean, we could say, well, everybody is against sexual discrimination and sexual harassment, but that's not the issue. The issue is whether they have advocated in their publications for any particular position or any particular side. Now, academic research is not necessarily advocacy, but advocates for the parties are going to use the publications that your faculty members have put out into the market to argue bias if they are operating in this world of sexual misconduct. So it's important just to be aware of that. Similarly, if you're using students, as some schools do, some schools will use a mixture of faculty and students. Some will use a faculty-run system, but it's not uncommon to see students participating on the panels. You're going to have to screen those students to determine whether they belong to or participate in activities or organizations that are advocating in this issue, in this area. Because if they are engaged in their own advocacy, the parties are going to have an argument that they are not free from bias and that they have some sort of conflict of interest. Now, of course, the safest approach, if you're looking at just risk management, would be to use an outside decision maker at the appeals decision point. You might hire a lawyer or a retired judge who knows how to run a hearing and have them come in and do the hearing and make the decision. But the decision maker is not just deciding whether the respondent is responsible, they are also deciding what the sanctions should be, what are the remedies. And so it occurs to me, having sat through a number of these, that you want a decision maker who understands your culture, who understands what remedies are available, what is appropriate and normative, what are the goals that you're trying to accomplish in your institution. And they may be different from institution to institution. Small institutions may have options that large institutions don't, and vice versa. And so using an outside person to be the decision maker may mitigate risk in terms of just their bias or conflict of interest, but it doesn't necessarily lead you to the most appropriate and student-sensitive outcome in terms of remedies. So I think that's something that we need to be thinking about. Now, prior to the formal hearing, the parties have to be given the opportunity, this is both parties, to inspect the investigative report and the evidence, that whether the evidence is included in the report or not, and whether it's what the regs refer to as inculpatory or exculpatory, at least 10 days prior to the hearing. And then during that 10-day period, the parties have to be allowed to provide any written response they want to make to anything in the record. And then a third requirement here is that the institution has to give written notice of any interview or meeting or hearing at which either party is invited or expected to attend. Now, when we get to the final determination in a minute, you're going to see that each of these steps that are described on this slide have to be documented, and each has to be included in the final determination. And then another requirement that is contained in the proposed regulations is that the investigation packet has to be available to the parties and their advocates on an electronic file sharing platform that permits access but does not allow printing. Obviously, the concern is we want you to have access to meaningful access to the full packet, but on the other hand, we don't want people making copies of it and spreading it around. However, in this day where everybody's cell phone is a camera, all you'd have to do is pull the packet up on your screen and take screenshots of it with your camera. And so as a practical matter, I'm not sure they really thought that through very well. But nevertheless, for now, the requirement is that you would have access to the records in an electronic form so that you could access them anytime. And when you get to the formal hearing itself, it's clear to me that the hearings and these formal processes are really contemplated by these regulations as being more in the category of what I would refer to as quasi-judicial than just an administrative hearing. In our world of administrative law, we often point out that we operate more informally. We don't have rules of evidence. We allow the decision maker to decide what's relevant or not without having to justify that. There are very specific requirements in these regulations about the hearings themselves. So the hearings are going to be more formal. They're going to be more trial-like than the informal administrative hearings that we've typically seen before. One of the requirements that is a significant change is that you must permit a lawyer to be involved for either side, and the lawyer is engaging as an advocate, and the lawyer is going to be able to participate in the process And so you're going to get more challenges to your evidentiary decisions. Those challenges are going to be more robust and technical because it's going to be a sophisticated individual sitting there. And so that's just something we're going to have to get used to. And then you have an emphasis on training decision makers on how to conduct the hearing, which is appropriate because if you're going to have a decision maker who is going to be making evidentiary calls with two attorneys sitting in the room challenging those calls, that decision maker is going to have a pretty sophisticated level of knowledge as to what is relevant, what is not relevant, and how you make that determination. And then there's an emphasis in the regulations on K through 12 schools that we're not talking about today. We're really focusing on higher education, but I would point out, if to the extent there are K-12 people that are listening in today, I know there are a few that we can talk to you about those offline and separately. But the key issue for K-12 schools is that there has to be notice, a right to tell the story, and a right to challenge the other side's story. Those three elements have to be present, but you don't have to have a formal hearing with cross-examination and all of that is required at the higher education level. The hearing has to be live at the higher education level. You cannot decide the case on the investigative record alone if either party wants to offer either witnesses or other evidence. Now, the burden of proof and of gathering the evidence is going to be on the school, not on the parties. Basically, the investigator is going to become like a prosecutor. They're going to have to collect the evidence, weigh the evidence, and bring forward a case. The parties can provide a list of witnesses, and the investigator should interview them, and so that's going to require training to make sure that your investigators know how to follow up on these things appropriately and gather all the information that's needed. But the burden of getting witnesses to come to the hearings and to participate and testify and all of that is going to be on the institution, whereas I think the general procedure previously has been to say to the parties, if you want somebody to testify, you should make sure they're there. That's up to you. That burden is being placed more heavily on the institution under these proposed regs. The next element of the proposed regulations that is a departure from the previous Obama-era guidance is this very strong emphasis on cross-examination. The presumption is that cross-examination is going to ensure a just procedure. So they want the cross-examination to be robust and to be effective, and the presumption is that will lead to more fair and accurate decisions. It is stated in the proposed regulations that if one party is provided an advisor, the institution must provide an advisor for the other party. It doesn't say that if one party has a lawyer, you have to provide the other party with a lawyer, but you do have to provide them with an advocate, with an advisor. And the advisors will do the cross-examinations. The party, him or herself, cannot do the cross-examination. An advisor or advocate must do the cross-examinations. Often in the past, we've had the panel chair or a member of the panel do cross-examinations. These advisors may be lawyers, may not be lawyers, but they're going to be doing the cross, and you still have rape shield principles that will apply to protect the complainant. So some of the questions that we need to be asking is, if one party has an attorney advisor, does the school have to provide the other party an attorney? We think not, but it's not entirely clear. While the school can still limit the participation of advisors as before, you cannot limit the advisor from doing the cross-examination. You can limit them from doing other things, but not from doing that. And then technology is a consideration. Again, the parties can request that they be in separate rooms during the hearing, but the cross-examination has to be an effective one, and so you have to have technology that allows you to both see and hear the other party during the cross-examination. So the often used technique of just having a visual barrier in the room between the parties where you can hear but not see the other party is going to be out with these regulations, and a technology, Skype type of technology will be more common in the future. In terms of the standard of proof, this is a really important aspect of these new regulations. You can use either preponderance of the evidence or clear and convincing evidence. One of the questions you're going to have is which makes more sense for you. And one of the things that I've been pondering is whether there's an alternative standard that might be appropriate that falls between preponderance and clear and convincing, that allows you to say, we don't want to move back to clear and convincing because that's going to create political issues that Mark's going to talk about in just a minute. But at the same time, we need to move somewhat away from preponderance because these close calls can sometimes lead to what appear to people to be an unjust result, and then you lose the confidence in the Title IX process. So we're thinking about standards such as a substantial preponderance of the evidence or significantly greater weight of the evidence, and we'll be giving greater consideration to those. But one of the requirements that you have to meet is that whatever standard you use has to be the same standard for students as the policies require that you use in faculty or staff cases. That's a significant addition, something new from the prior guidance, so that whatever you're doing across the board in the Title IX context, you're doing consistently. Your decision makers are going to have enhanced responsibilities. They're going to have to be trained. They're going to have to understand how to make relevance calls and other types of evidentiary calls. And they have to state in writing why they exclude any evidence or testimony. Interestingly, trial judges in judicial cases don't even have to do that. They can admit or not admit evidence, but in this case, you're going to have to articulate why you keep any evidence out so that that can be examined later. And then there will be a written determination that's required. And the elements of the written determination are set forth on this slide. You have to identify the section of the code of conduct that's being violated or is allegedly violated, the procedural steps and required notices that each of those things was actually done, the findings of fact that support the determination, the rationale for the decision as to each allegation, and then the remedies to be applied and the appeal rights available. All of those elements have to be in the written determination. As far as remedies are concerned, the regulations do expand the availability of remedies. As Melissa mentioned, there's more flexibility in these regulations than we had in the Obama-era guidance. The focus is what remedy is going to be provided to the complainant to enable her to access the benefits of the educational program, and what sanctions are going to be applied to the responsible respondent if he's found to be responsible. And then finally, we have appeals. If you offer an appeal, which you don't have to do under the regulations, but if you do offer an appeal, you have to give either party access to the appeal. The complainant can appeal the finding of not responsible. The complainant can appeal the sanction, whether it's sufficient against the responsible respondent, or the remedies available to her. So any of those elements can be appealed. Likewise, the respondent can appeal any aspect of the determination. So you could have cross appeals. You could say, the respondent could be saying, I wasn't responsible, that's the wrong decision. The complainant could be saying he was responsible and you should be doing more. And then as with the investigation and the hearing, the appeal decision maker has to be free from bias, conflict of interest, or involvement in the investigation or hearing. Now, implementing all of this is going to create some public relations issues for you, and for that reason, we wanted to have Mark talk to you about how to manage that process. So I'm going to turn it over to Mark.
Thanks very much, Craig, and thank you all for joining us for this webinar. We certainly want to be very respectful of your time, and I want to let you know that I'm just going to be making a few overarching comments as this all relates to public communications, the various audiences that you are working with and talking to every day, and the degree of interest and attention that's being given this matter, but we'll be doing so in just a few minutes of time so that we can wrap up right around our 1 hour of scheduled time. Clearly, this is an issue that is getting a great deal of public attention. The Department of Education issued a lengthy press release itself when the proposed changes were issued, and this quote from the Secretary of Education was the most used quote in all of the news articles that I reviewed, and I think it's emblematic of what they're trying to accomplish and what you are all facing at your individual institutions, and that is showing some deference to both sides and making sure that you are doing that. She stated, every survivor of sexual violence must be taken seriously, and every student accused of sexual misconduct must know that guilt is not predetermined. So I think what's essential for you as you work with your communications teams and departments is that whatever decisions you make on the myriad of areas that have been covered by both Melissa and Craig on this call, it's going to reflect that you looked at both sides of the issue and that you gave consideration to both complainants and respondents in whatever it is that you decided to do. In terms of the press coverage, which I know many of you have been following, certainly the victims' rights and the victims' advocates groups have been the most vocal about these proposed changes. I'd say they're probably at least 10 to 1 out there in terms of making comments, generating stories, and controlling the narrative. And this example is certainly shows what many are saying, which is that colleges will find it harder to convey the support and protections that sexual assault survivors deserve. And many of the comments being made by the advocacy groups are along these lines, that these proposed changes do not help the victims in these cases as much as they could potentially help the accused in these cases, and that's just something that will need to be considered and weighed as you make your decisions so that you're protecting both sides. There has been some public comment made on the other side of the issue from the other viewpoint, generally from those who do represent directly accused students, and it falls something along the line of this quote, which is, there is no better way to test the truthfulness of an accusation than by questioning the accuser during a live hearing. If colleges are going to adjudicate what are essentially crimes, then accused students deserve to have the tools to defend themselves effectively. I think what all of this indicates is that the real question is, how have we been communicating on Title IX issues and cases up until this point, and how do these proposed changes impact how we're going to be communicating going forward? And what we have shared with the colleges and universities that we've been working with in Title IX cases up till now is that obviously, because of privacy issues, you're very limited on the specifics that you can share in a public forum about how you're addressing the accusations that have been made. Certainly on the record. There's some things you can do off the record. That's a whole different topic for another day. But what colleges and universities can do and have been doing and should be doing is explaining to the public when there is a high-profile case what their protocols are for responding to and investigating a rape, harassment, or sexual assault allegation. And then they should be explaining very clearly what their policies are for the decision-making process throughout the investigation, and as well what the appeals process is and what the results of the investigation have been. Additionally, schools should be very proactive in sharing what resources and support systems they have available to all of their students to provide a safe environment and to help them in the case that they feel that they have been victimized in some way. And then there also are very important education programs that each college and university has, not only for incoming students, but also available to all students, so they're aware of all of the resources that are available to them and what are the actions and procedures that the college or university is going to take when any complaint comes its way. So the question becomes then, what changes now that we have these proposed regulations? And essentially, privacy remains in place. We can't change any of that. The sharing of all of your proactive efforts and what you do to protect the safety and welfare of all students, that stays the same. Explaining and defending the options, though, that you're selecting under these new rules is what's going to shift. And that is going to require very proactive communications on your part. You are going to want to share with audiences what process you are using for determining which options you are going to take and enforce going forward. And you're going to want to share how you've engaged with those audiences. Are you going to have town hall meetings on your campus? Are you going to put together a task force? Is this going to be done just on an administrative level? Transparency does build trust, and it's very important that you are sharing publicly with all of your audiences what you're doing and how you're doing it throughout the process. It's very possible that what your individual school does may not get a lot of attention at this time or during the process, but what we do know from experience is that if you wind up facing a high-profile Title IX case, you will get intensely under the microscope in terms of what you did, how you did it, when you did it, setting up all of your policies and procedures. And it is a lot easier to face the public scrutiny of the actual accusations in a Title IX case if you can very clearly define and explain how it is you came to establishing the policies, procedures, and protocols that you are implementing.
Thank you, Mark. So as we get to the end of our hour, we have received a few questions. Most of them seem to be sort of specific to a particular context. So we're going to get back to you with answers to those questions today or no later than tomorrow. But we do want to respond to each of you who asked a question. To all of you, let me say thank you for taking time from your busy schedule to join us. We have a lot of people on the call. We know this is important to you. We want to be able to assist you through this transition to a new regulatory scheme. And if you have questions after today that you didn't submit through the process, we would be more than happy to talk to you anytime about that. Just reach out to any member of our education team, and we'll work with you. And with that, we thank you, and we're going to bring this to a close.